Good afternoon, good evening, and good morning, depending on where you are. My name is Inxia. Welcome to the book talk series of the Center for Comparative and Public Law at HKU Faculty of Law. I see that we have quite a lot of attendees on a weekday evening, so I assume that you're all very excited, as I am, about today's discussion. Today, we are delighted to have three wonderful speakers to discuss the issues of gender and the court system in China. Gender equality and judicial reform are both hotly debated among scholars of Chinese law and citizens in China in these days. And I think no time is better than now to discuss the intersection of these two emerging issues. Today's discussion will be based on Professor Michelson's new book, Decoupling, Gender Injustice and Divorce Courts in China. Professor Ethan Michelson is the chair of the Department of East Asian Languages and Cultures at Indiana University and the academic director of the university's China Gateway. Ethan has researched and published extensively on the Chinese legal profession, dispute resolution, and gender issues. Our two discussants today are also experts on those issues. Our first discussant, Professor Qian Liu, is an assistant professor at Calgary University, Department of Sociology. Qian's research interests include feminist legal theory, genders and China, and law and society. Our second discussant, Professor Sida Liu, is an associate professor at the Department of Sociology, University of Toronto. Sida is one of the leading scholars on China's legal reform and legal profession, and is also written on interplay between gender, legal profession, and social movement in China. So without any further ado, I will now pass the floor to our speakers. Ethan, please.
Thank you, Ying. It's really great to be here, and I want to thank those of you in the audience who are in Hong Kong or elsewhere in Asia for staying up so late for this event. It's pretty late in the evening, and you're doing so to accommodate those of us who are in the Eastern time zone. So I also want to give a big thanks to Qian, who got up really early before dawn, before sunrise, where to be part of this panel in Calgary, where it's only 7 o'clock in the morning. Although it's impossible to know how to pronounce my name from the spelling, people often pronounce it Michelson. That's very, very common. It's actually pronounced Michelson. It's not intuitive. Although I do have relatives with the same name who pronounce their name Michelson. So there are different ways that some people say Michelson. Well, I pronounce it Michelson. My family is Michelson. But other people with the same spelling will pronounce it Michelson or even Michelson. So there's just no way to know. I'm going to try and keep my comments brief because, frankly, what Qian and Sida have to say will be a lot more interesting and valuable. I want to thank them not only for being here, but for reading an excessively long book. It's well, you can't see it with the. Don't you love the virtual backgrounds? Just make everything invisible. I'm like trying to hold up the book here and. There, how about that? Oh, right in front of my face. I'm particularly eager to hear their feedback for a couple of reasons. The first reason is that I admire their research on law, society, and gender in China. I've been friends with Sida for over 20 years now, and we've co-authored stuff. And throughout all of this time that we've been colleagues and friends, he's been always 100% tan shui, just like really frank and direct. And I expect no less today from him and also from Qian. The second reason is that I'm really curious and interested because I received virtually no feedback from anyone at all about this book. And the reason is because nobody except me, my freelance editor, my copy editor, and my proofreader actually read the book before it was published. That may seem kind of shocking. I took a big risk by just publishing the book pretty much sight on, like no one else had really vetted the book. I mean, Cambridge, of course, the publisher, they sent the book proposal out to reviewers. And actually the two reviewers, they were the two Margarets, Margaret Wu and Margaret Boyton. another Canadian. So I'm actually happy to be. This is a Canadian panel here. Both Chen and THUR belong to Canadian universities. I'm originally from Canada. So Margaret Boyton, who's at Osgoode Hall at York University, was one of the reviewers. They both gave great comments and feedback. But the draft manuscript that they reviewed and that the press approved was very different from the final version that I submitted for publication. And the press just they didn't send it back out. The final version that I submitted, they just put straight into production. I did not do a book workshop, nor did I send it out to colleagues for comments, except for the intro chapter, which I sent to one colleague. So I felt a little weird about publishing a book that really hadn't been read by anybody except me. Basically, in the book, I analyze almost 150,000 divorce adjudications, and so these are trials, right? 判决书 from two provinces, Henan and Zhejiang, between the years 2009 and 2016. And the key findings include the following. Domestic violence allegations were extremely common. About 25% of all first attempt divorce petitions included domestic violence claims of various kinds of marital abuse. And close to 40% of divorce petitions filed by women, right, contained these sorts of allegations. And this reflects the simple fact that almost 70% of divorce petitions were filed by women. Women often meticulously supported their allegations of domestic violence with admissible evidence. And yet, women's allegations and evidence of domestic violence were of absolutely no help whatsoever in their efforts to divorce their abusive husbands, even though the law very clearly tells judges to grant their divorce petitions in situations like this. So overall, judges denied most divorces the first time they were filed and granted them when plaintiffs returned for another try, at least 6 months later. And domestic violence allegations did not increase judges' willingness to grant divorce requests. In fact, the data show a clear clampdown on divorce, meaning that judges became increasingly likely to deny divorce requests over time, right? So over this time period from 2009 to 2016. When judges did grant divorces, they actually routinely granted child custody to wife beaters, right, to the abusive husbands. By denying divorce requests involving domestic violence and by routinely granting child custody to abusive husbands, judges are in clear violation of China's own laws. The civil procedure law, including evidence law and family law and other kinds of laws. So the problem is not really with the laws themselves. The laws themselves are actually quite good. It's the way the laws are interpreted and implemented, and really, I mean, the way they're not implemented, the way they're ignored, and the different kinds of pretexts that judges use to ignore the laws when they really unlawfully deny divorce requests. The period of analysis ends in 2016, as I've mentioned. It's hard to know whether anything has changed since 2016, whether the situation has improved, but we just don't know. I mean, it's really hard to know. But the anecdotal reports, really media reports, suggest that problems persist. So let me give you an example of a pretty typical case. So there was a report, just a recent one. The media will occasionally report the kinds of divorce cases that appear throughout the book. So here's one that I just read about maybe about a month ago. It's a case from a few months ago, so in April of this year, the basic level court of the city of Changge in Henan province denied the divorce petition of a woman named Han Qing, whose husband not only admitted beating her, but he also agreed to the divorce, right? He consented to the divorce, and he said, "Yeah, I beat her, and I'm willing to divorce." They married in the summer of 2018, and according to the plaintiff, he first started beating her in early 2019, about 2 months after she had her first child. In her words, and this is a quote, "He's trained as a boxer. He always goes for the head first and packs a powerful punch. When she was pregnant, he kicked her stomach and beat her head." She sought police help on several occasions, right? So she reported this to the police, 报警了, several times. According to the court decision, her husband admitted beating her, but he denied that the beatings amounted to domestic violence. The husband stated, and this is a quote, "Only when verbal and physical abuse is one-sided does it count as domestic violence," unquote. To justify its ruling, the court wrote, and this is just so typical, family is the basic cell of society. Family stability is linked to social stability. So 家庭是社会的基本细胞，家庭的稳定，维系着社会的稳定. The law will not protect marriages devoid of mutual affection. But hair-trigger divorce, this is what the court said, hair-trigger divorce, so 动辄离婚. Oftentimes courts will refer, for decades, courts have been referring to this as like 轻率离婚 or 草率离婚, is also unsupported by the law. And the court went on to say that because the violence was both ways, right, it was mutual hitting, the plaintiff's petition failed to satisfy a fault-based statutory condition of divorce. Finally, the court said that even though both sides consented to divorce, it could not grant the divorce because both sides couldn't come to an agreement on child custody and property division. Besides, the court added, divorce would undermine the interests of their 2 young children. So the court denied the petition on these grounds. Totally unlawfully on multiple grounds, right? The domestic violence. The courts are if they grant the divorce, and they should have granted the divorce in this case, it's their job to settle property division and child custody, but the court said the onus was on the 2 litigants, which is simply not true. And the argument that, well, that in the interests of the children, we have to preserve the marriage, that also has no legal basis whatsoever. But as I show in the book, a case like this is an utterly typical case. Sadly, the only surprising thing about this case is that anyone finds it surprising enough to be newsworthy, that this made it to the news. There have been a few similar news stories over the past couple of years. There's, that have attracted a lot of attention. The 2020 divorce case filed by a woman who jumped out of a second-floor window, and also in Henan, in Zhejiang County. There was another case, a divorce case of an abused woman who filed her 5th divorce petition in Hunan, not in Hunan, in Hengyang County's People's Court in Hunan. And the media when they report cases like this, it's as if they sort of frame these cases as if they're exposing extreme cases of injustice, like crazy decisions of out of control judges. And in fact, media reports like this, they do spark public outrage, that do put a lot of pressure on courts. And in cases like these, the courts actually have to, they under public pressure, they do reverse their decisions. But what most people don't realize is that there's nothing unusual about cases like these at all. Like pretty much, what I'm trying to do in the book is to show that pretty much every basic level court in China makes decisions like this every single day. There are thousands and thousands of cases. Tens of thousands of cases, just like these ones, hiding in plain sight. These cases are publicly available. That's how I got, well, at least they were. That's how I accessed the data. From scraping public websites. What I show in the book is that these decisions, these judicial decisions, they're boilerplate. applied mechanically and sort of mindlessly by judges to divorce petitions that strictly according to the law should be granted. And judges, they don't care about the specific circumstances of the cases. They just uniformly, like 一刀切, that's sort of how it's described in Chinese, uniformly tell plaintiffs, basically, sorry, you proved that your husband beat you, but you didn't prove that the beating rose to the level of domestic violence. That's one common thing. And you therefore did not prove the breakdown of mutual affection. 感情破裂, that's the basic legal standard, right? And if you work harder, this is what they tell the plaintiff and the defendant, if you work harder to improve your communication, if you learn to compromise and to give and take, and if you work hard, blah, 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 you can rebuild and restore this marriage. And this is, regardless of how horrifying and well documented the violence was. And I want to be clear that this general pattern of denying divorce petitions the first time that they're filed it's not one of the book's original contributions. Other people have been showing the same thing for decades. I certainly don't take credit. I don't claim credit for this particular finding. You don't need to read my book to learn about this pattern. Previous studies have also shown that this pattern of denying, first attempt divorce petitions and granting subsequent attempt divorce petitions, that it extends even to domestic violence cases in which the law fully supports granting divorce petitions. However, the previous studies have been largely qualitative or based on small samples of court decisions, sometimes from only from one or a few courts. And so what I'm able to do is to confirm these previous studies using far more comprehensive data. I demonstrate that these outrageous and unlawful judicial decisions, they're ubiquitous. Every single one of Henan and Zhejiang's 252 basic level courts, follow this pattern. So one of my objectives in writing the book, and admittedly, this is a naive objection, was to show readers just how common cases like the few sensational ones portrayed in the media are, including the one that I just summarized. In my again, admittedly naive hope that court leaders would be sufficiently embarrassed to begin to implement changes. This is one of the reasons why I included in the book so many really just gory, harrowing details from women's accounts of domestic violence. Some people have told me that parts of the book are difficult to read because they're just so disturbing. I quote verbatim from a lot of the plaintiffs' petitions, and they're describing in meticulous detail what their husbands did to them, and so part of this goal of mine is one of the reasons why the book is open access. It's freely available to the public everywhere in the world. I mean, if you want the hardcover edition of this book, you got to pay $155 for it. But if you're okay with the PDF version, it's free. The book it's mixed methods, and now after showing the book cover, I'm totally out of focus, but that's okay. So in terms of methods, I use computational techniques to make sense of the contents of almost 150,000 divorce decisions. I mean, I didn't read all 150,000 of them. I read a lot of them. I read, probably, hundreds of them at least, maybe 1,000. So these techniques, these methods include natural language processing to identify common sets of vocabulary in plaintiffs' petitions and in judges' holdings. But I do also do a lot of qualitative analysis. I read these cases and I to illustrate, I have a lot of case examples throughout the book to illustrate common themes that emerged from the qualitative analysis. Oh, sorry, from the quantitative analysis. So the quantitative analysis shows like, basic patterns, right? And then I illustrate these basic patterns. I sort of flesh them out with lots of qualitative examples. I did not interview anybody. Okay, I didn't conduct any firsthand observations. I didn't talk to any judges. I didn't talk to any litigants. I didn't hang out in the offices of legal workers and listen to how women talk to legal professionals. Other books do those things. So, so Curly's new book, Marriage Unbound, does that. That's the real ethnography. Sheena He's book, Divorce in China, is also a qualitative book, in sort of takes that approach. Although I didn't interview any judges, their voices they're everywhere throughout my book. Not only from their written holdings, right, but also from their published articles. I mean, judges are constantly publishing stuff. They're writing about their experiences as judges. They have to. Actually, this is part of their annual reviews. They get their performance is evaluated in part according to their publications. So they're posting stuff online constantly and publishing journal articles, and they're writing like very openly and frankly about their challenges and their problems and their difficulties, how they deal with them. So I was able to include the voices of judges, also from the secondary scholarly literature, other people who did interview judges, right? I was able to quote from those studies. So, by being able to sit in my office for a few years and just analyze these, tens of thousands of cases, and it was in some ways it was the perfect pandemic project, right? I didn't have to go anywhere. I didn't have to do field work. Another contribution, so like I said, some of the findings and arguments, they're not original, but I'm trying to make a methodological contribution. One of my goals was to establish best practices for how to analyze huge collections of court decisions like this, right? When, about 10 years ago, when courts started to publish their decisions online, I mean, scholars immediately started to kind of salivate, right? They were drooling, like, oh my God, this is like lots of data, lots of court decisions, and lots of people have been trying to figure out how to analyze these court decisions, and there are tons and tons and tons of studies that analyze court decisions, but most of them, almost all of them, in fact, are pretty small samples. They do like keyword searches, and then they like manually code, they hand code. They'll analyze like 200 decisions or a few hundred decisions and hand code them and analyze them. But there are very, very few studies that analyze like over 100,000 or millions of cases. They're starting to come out now, but I wanted my book to serve as kind of a guide, right, or a manual for analyzing like just massive collections of court decisions that China's courts have been posting online. I mean, it's interesting. I mean, there was this moment, there was a period of great optimism as the Supreme People's Court, right, was its website, China Judgments Online, 中国裁判文书网, was growing and growing and growing. But then it just became increasingly difficult to scrape, and now basically impossible to scrape. And now there are all kinds of reports that the Supreme People's Court has been like removing cases from China Judgments Online. I mean, there are some commercial alternatives, but right now it's like really unclear actually what we're going to be able to do with these cases, if anything. I wanted to say something. I'm kind of running out of time, and I want to make sure that the other panelists have time to comment. But another, I guess, the final contribution that I wanted to talk about briefly actually has almost nothing to do with where it's related, but not totally about divorce litigation. In fact, it sort of goes beyond. One of the contributions of the book, my hope was to kind of go beyond divorce litigation. So I try and actually take a step back and from divorce litigation and analyze variation in the working conditions of judges. I mean, the working conditions of judges really help us understand why they sweep divorce cases aside, right? Why they just like push them out of the way, and they routinely deny divorce petitions. I show that the courts that deny the highest proportion of divorce petitions are precisely the courts where judges' caseloads are the heaviest. So in other words, the problem of overworked judges, what Chinese scholars and judges call 案多人少, right? The problem of many cases and few judges, that this explains a lot of the variation in how courts deal with divorce petitions. And that getting rid of divorce cases is one of many strategies that courts have developed for coping with their oppressive caseloads. It's not the only strategy. There are other strategies, right? Like putting assistant judges on collegial panels. That strategy, it still exists, but it's become harder after the judge quota reform, after assistant judges as a category was sort of eliminated. Another strategy, to expand, it's been expanding the scope of the simplified procedure to cases that are actually quite complex and really should not be tried according to the simplified procedure. I'm not going to elaborate that because I'm out of time. Recruiting more lay assessors, that's been a big strategy. So the upshot is that hardly any cases are tried by traditional 3-judge collegial panels anymore. In fact, over the past 10 years or so, the 3-judge collegial panel has become virtually extinct. I mean, this has been kind of an invisible revolution. As far as I know, no one has written about it. It's gone largely unnoticed, I think, even by Chinese scholars. And the reason is simple. It's almost impossible to discern this trend from judicial statistics, but it can be discerned from collections of court decisions like mine. So this is the focus of chapter 5, which I call many cases, few judges, 案多人少, about the vanishing 3-judge trial. Now, the reason I'm pointing this out, not just about what I hope one of my contributions is, but one of the reasons why the book is so long. I mean, it takes me 6 or 7 chapters before I finally really dive into the divorce cases. There's so much of the book is just sort of like setting the stage. I wanted actually to get rid of that chapter on the many cases, few judges. I wanted to publish it as a standalone journal article. I thought it would be interesting to people who in comparative law, who care about courts, who might not have a particular interest in gender or divorce, family law. But I just couldn't figure out how to extract that chapter. So much of the book depended on understanding divorce cases depended on that. I tried desperately. I agonized for months over how to reduce the length of the book. I was thinking, okay, I could get rid of that chapter or other chapters, publish them as journal articles, and then cite them. But I couldn't. They were just too intertwined and entangled with the other chapters. I was thinking, okay, what if I split it into 2 books, like volume 1 and volume 2? I couldn't do that either, because there would be no easy way to begin volume 2 without someone wouldn't be able to start reading it without reading volume 1 first. Anyway, I wanted to. I always get questions about the Henan and Zhejiang comparison, the 2-province comparison, but it makes perfect sense. It really only makes sense with respect to the workloads of judges. That's the only, Zhejiang's overworked. Their judges are so much more overworked, and that's precisely why, their caseloads, their dockets are so much heavier than those of their counterparts in Henan, which is precisely why it's so much harder to get divorced in Zhejiang than it is in Henan. So that the 2-province comparison totally makes sense. I'm going to stop right here. I think I said pretty much everything I wanted to say. I took way longer than I'd hoped, but we still have an hour left. So I'll thank you, and I'll turn it over to Chen.
Thank you. Thank you so much, Ethan. I think what I have to say overlap a lot with what you just said. So I just want to let the audience know we did not really communicate before we came up here. I have a lot to say within my 15 minutes, and probably I will also go over a little bit. And of course, I will have a lot to say. This is a very rich book, not just because it has more than 500 pages. I took it with me to Lisbon when I was traveling for the Law and Society annual meeting earlier this month. And I ended up enjoying reading it too much that I did not get to see much of what Lisbon has to offer. So be careful when you pick it up. You won't be able to put it down easily. I spent 2 days reading Decoupling at a small coffee shop near where I stay. And I think it was probably not the best way to use my funding to fly across the world and do something like this. Let me just briefly talk about what I have learned from this book, from reading Decoupling as a law and society scholar whose research focuses on gender in China, focuses on family relations and Chinese legal culture and legal consciousness. To me, Decoupling is inspiring in many, many ways. First, Decoupling does a very good job in telling stories of gender inequality, women's struggling and pain, and even their resistance. And this is done by using a huge set of judgments published online, both qualitatively and quantitatively, as Ethan just said. And to me, this is really an innovative approach. It points out an important, a very important direction for us, for Chinese law and society scholars to conduct our research on China. Decoupling tells law and society scholars whose research focus on China that there are still many things we can do, even if empirical research is becoming very, very difficult, if not impossible, in mainland China. For those of us who are considering shifting our attention away from empirical research in China, we see hope. We see hope to continue this important work. So I have to admit that I was thinking about doing something else. I was thinking about giving up, but after reading this, I think maybe I should stick to that. There is still ways to do important research about China, and we need to do this important work because there are people there, there are judges there waiting to be educated, and there are ordinary people there that we need to convey our message to them. So how does Decoupling give us hope in this dark period of time? I'm not trying to say I see the future of Chinese women who suffered from domestic violence or the future of the Chinese legal system. The situation was really depressing. I think every single woman considering getting married should read Decoupling and think twice, perhaps even considering putting in a period of cooling off period for yourself before you rush into marriage. Because it's just really difficult for you to get out of it based on the finding of the book. And what I mean by hope is a methodology or a way of using Chinese judgments published online to continue telling stories in a very engaging way about justice and injustice. And what I see from Decoupling is a methodology that enables us to have engaging stories and solid numbers and evidence at the same time. A methodology that allows us to have the benefit of both qualitative and quantitative research. And we don't have to worry about not being able to travel and get the data ourselves in person. We can just sit comfortably in our office and do this important work. And I think there are many legal scholars out there like me who always knew, well, probably we could do something with this large data set of court cases published online. But I wasn't very confident about this approach as a qualitative researcher. I did not know how much we could get out of it until I read Decoupling. To be honest, Chinese judgments are quite easy to read, but reading these cases is not an easy task. It's really, I mean, it's easy to read because as Ethan points out in the book, judges don't have time to write long and detailed judgments, and they recycle their judgments regularly, and they often put in some like useful bullshit, like meaning political or moral statements about like social stability, like family harmony, something like that. So they are useful to judges because it takes up a lot of space in their judgments. They save them the work to write more, but not useful to the readers. So I struggled a lot when I had to read these cases for information. But it is from thousands of these seeming like appearing to be very boring cases that Ethan put together a book that captures the struggling, the suffering, the resistance, and the emotion of the women involved in these divorce cases, and even the emotion of their parents, the situation of their children, and also the village fellows and more. Decoupling has many engaging stories from both urban and rural China, and it surprised me how much a legal scholar can do without conducting interviews, without going to the field, and how many vivid stories one can bring out to make it a very emotional read for the readers without like being in the field and talking to people. Be prepared to be upset when you read a book. You will be very upset about the inequality, injustice women have to go through when they go to the court to fight justice. Ethan draws upon a large data set to demonstrate how judges like represented domestic violence victims as overly emotional, as someone who is like neglecting the interest of the trial, as someone who take away the benefit of having an intact family for the trials growing up, and also being a bad citizen because if you are not maintaining your family harmony, you are really not maintaining social stability as a Chinese citizen. And using these cases available to the public, Ethan gives us hope by bringing out emotion from those court decisions and making the process of reading emotional. And now I know we, as law and society scholars, we can always find ways to conduct our research in a political and social environment that may not encourage us to do this type of work. Decoupling also leaves us wanting to know more about the emotion of Chinese judges who turn away these women, who ignore the evidence of domestic violence and left these women in danger by denying their first petitions, and who try to sometimes persuade victims of domestic violence to withdraw their claims for trial custody and property rights, and who granted trial custody to fathers who abused their mothers. And I have to admit that I hate Chinese judges after reading Decoupling, but the book helps me think through the process and digest my emotion right away. One great thing about Decoupling is that it also reminds me of the fact that judges themselves, they are victims of the very heavy case law that they are victims of the system, it reminds me of the pressure for judges to make no mistakes legally or like politically without being able to control all those factors that could lead to extreme violence or something like that. And decoupling captures the dilemma and struggles of the judges themselves. I'm grateful to Ethan for making the connections between judges' reluctance to grant justice with connecting this with their workload, as well as the very fact that sometimes political ideology such as maintaining social stability and family harmony and something like upholding the core values of socialism could be judges' best friend when they have to find excuses or justifications to reduce their own workload. And this connection answers many questions I had about Chinese courts and how Chinese judges worked. I remember asking a judge how she felt when she had to make a decision that was against her understanding of justice. This was a while ago when I was doing my own research on the elderly law in China. And the judge said, I feel nothing. I'm used to that. I have more than 300 cases per year. Life has to move on. I don't have time to be emotional. And I forget about them when I move on to my next case. The judge went to law school together with me, and she's a good human being. She's a good friend. She has feelings and kindness. For a long time, I found it very difficult for me to accept her way of dealing with her work and using her power. But after reading Decoupling, I realized that granting justice is probably not something she could afford to do. In a sense, decoupling not only enables me to understand the Chinese court system, but also saves my friendship with my classmate. So with these connections made by decoupling in mind, I went back to my previous interview transcription and found this paragraph. It was from one of the civil court judges I spoke with about why they kept imposing legal obligation on adult children to offer emotional support and financial support. Even the aging parents were responsible for the breakdown of family relations, including parents using violence against their adult children. And here's what the judge told me. Judges could not promote the idea of seeking revenge among family members. We have to emphasize harmony and love with an aim for reconciliation. We need to offer more opportunities for family members to develop good relationships, during which process maybe parents may realize they had done something wrong in the past and may decide to help their adult children with childcare and other tasks in everyday life. At the same time, judges have to take factors such as social impact and stability into consideration. What if aging parents sought revenge by attacking other people on the street or committing suicide? As a judge, you cannot push a person into despair. So after reading Decoupling, I now have a much better understanding of what she said. And the reason I bring up this example is to demonstrate that the findings of Decoupling could travel outside diverse courts and be applied directly to understanding how judges deal with other type of cases in Chinese courts. And my final point is about decoupling's theoretical contribution to law and society scholarship and focusing on my own research areas of Chinese law and society and legal pluralism. I think I have talked much about the what Chinese law and society scholars could benefit from the book. especially those who study Chinese courts, family relations, and gender inequality. And one more thing I really appreciate is that decoupling keeps reminding us of the differences between rural and urban China. And I think we, as Chinese law and society scholars, we have to pay more attention to this difference when we use the term China. Like, China is so big, it's so different. That is there really a thing as China in our research? We might have to give more details and be clear about like which areas we are talking about. And to me, Decoupling is also a book for scholars who are interested in legal pluralism, both in and outside China. Although Ethan does not use the term legal pluralism throughout the book. Decoupling tells us how laws and policies are made by frontline workers, such as judges. And it reminds us of the importance to pay attention to the gap between official laws, policies, and the daily practices of civil servants that may be primarily based on unspoken and unofficial rules. From this perspective, I think Chinese courts are clearly a site of legal pluralism for future research. I have been probably talking too long, and let me just end with a few questions for Ethan. These questions are also closely related to my comments. So my first question is about methodology. I'm wondering whether you have any suggestions for those who are interested in using China's online judgment database or something similar for their future research, and what difficulties they should anticipate, or perhaps what difficulties you have encountered in the process you think they should know. So this is my first question. My second question is on knowledge mobilization. I think you clearly have findings that are too important to be kept to scholars. And I wonder whether you have any plan to attract a wider audience, especially those whose work involve law and family relations. I mean, all Chinese judges dealing with diverse cases should read Decoupling, especially the 4 chapters towards the end on the consequences of not being able to get justice in court. And my last question is on emotion. I know the feeling of reading through cases that are against what we believe to be justice. And sometimes I found myself very upset with court decisions related to family relations. And sometimes I could not read too much within a short period of time because it was just too heavy. And my question is, how did you digest your emotion when you read through all thousands of these cases? Thank you. I think I will just stop there. Oh,
yes, I'm back. Yeah. So thank you, Chen. I asked Chen to go first in the discussion because if I go second, I can speak shorter. Because she already raised a lot of comments and questions I was about to raise. So I can't promise my comments will be as polished as Chen's, but I can promise I'll be 100% frank. As Ethan said, the two of us has known each other for 2 decades now. So let me first say that, for those of you in the audience who are not aware of this, this book is part of the trilogy on China's divorce, marriage and divorce law that published in the past year. The other 2 books, as Ethan mentioned, is Professor He Xin's book, Divorce in China, and also Professor Li Ke's book, Marriage Unbound. So the 3 books are really, if you put the 3 books together, they really present a very comprehensive picture of what marriage law and how marriage law operates in China, and especially how divorce disputes are handled in courts from very different theoretical perspectives. I think He Xin's book is more like what I call institutional approach. And he basically focused on judges' behavior in court and how judges are embedded in the court, and also how they care about efficiency, stability, all these things, how those shape their approach to divorce cases. And Liko's book, I think I would more characterize as like a cultural approach, as she really traced the kind of the cultural meanings of these divorce disputes, all these kind of principles and norms that emerge in the divorce practice, and also a more historical approach goes all the way back ever since the founding of the PRC and for the past half a century, right? And so what is the approach of decoupling? Ethan's book. After reading the book, I thought about it. I think the best way to think about to talk about the approach of decoupling is a more methodological rather than a theoretical approach, but it's a methodological approach that has theoretical implications. I think the best way to call it is just to call it a big data approach, the most simple way to call it. Why? Because as Ethan mentioned, ever since the 中国裁判文书网 was online. It's been, more than probably 7-8 years now. So there have been numerous studies trying, scholars trying to make use of this data source. And I very much share Ethan's sentiment that the vast majority of these studies are very disappointing in the sense that they basically do either of the two things or both of the two things. Either they focus on a very small number of cases and kind of, read the decisions and then try to generalize from a small number of cases, not really making use of the big data in the big data way. And also they're also very superficial big data studies, claim to draw on hundreds of thousands or even millions of cases, but actually do very simple descriptive analysis without actually showing the rigor of analysis that you can possibly do with a million cases, for example. And so for a while I even became very skeptical. Of course, I'm a qualitative sociologist. I've always been skeptical about all these quantitative studies, but especially for these kind of big data approach to the 中国裁判文书网, I think most of the studies are very disappointing. But this book is actually one of the few exceptions. I think, as Ethan said, he wants to set a kind of a best practice book. I think he succeeded in doing that because I think by far this is the most sophisticated and rigorous use of the 裁判文书网 to do the kind of big data analysis on Chinese court cases, not just for divorce cases, but I think it's an example for all kinds of big data kind of analysis for court cases. And there's something very, very attractive about this approach, which I really appreciate. When reading the book. And I can give many, many examples, but let me just give one very simple example from chapter 4, which has very little to do with divorce, which is what Ethan called the disappearance of the 3-judge panel. And, we kind of all know that, in the civil procedure law, for example, a civil trial, a standard civil trial should have a panel of 3 judges, right? But empirically, we kind of know qualitatively that a lot of Chinese trials are actually, there's 1 judge in charge, and the other 2 judges are just sitting there without doing much work. And sometimes it's 1 judge versus some lay assessors, and sometimes it's like a single judge panel, a simplified procedure. But what Ethan showed in chapter 4 was the data for divorce cases, but also for all kind of civil cases, is that there's this dramatic decline in the actual use of 3-judge panels, in the 2010s, basically in the past 10 years. The majority of cases are either by 1 judge versus 2 lay assessors, or by a single judge. In deciding on divorce cases and more generally civil cases. And it's very, very striking. And that's the kind of results you can only show with, the big data approach with hundreds of thousands of cases. Because, if you observe qualitatively, people can always say, oh, this is just this 1 court, or this is just this 1 province. But that's actually almost like a slam dunk kind of evidence about that. Of course, there are many other examples you read on, as Qian mentioned, some of the best and most striking findings of the book are in the final 3 or 4 chapters. I mean, for example, like it shows basically the irrelevance of domestic violence in the decision for granting divorce, or the decision on child custody. So it's the physical possession of the child is much more significant than who's at fault or whether it's there's domestic violence in the course. I think those results, those are hard numbers. And as Qian said, I mean, I think all Chinese judges and all students of Chinese marriage law and divorce law should read those chapters and read those results, because those are a lot more striking, I think, than just giving an ethnographic story about a famous case or outrageous case somewhere, right? So I think that's really the attractiveness of the big data approach. I think Ethan really kind of drove it home in this book. And I think it is really exemplary in that sense for many other people who want to use the Taipang and Zhuang to do more empirical studies. But of course, at the same time, the big data approach has its own limitations, and there's several limitations. I mean, it's not really Ethan's problem, it's more the data limitation. The most obvious one, I mean, of course, and Ethan actually flagged this multiple times in the book, which is they're actually quite, if you look at the divorce case, all divorce in China, and the divorce cases in court, divorce cases in court is only about 15% of all divorce, right? 85% was actually the divorces was granted by the Civil Affairs Bureau, and it's very, very easy, almost too easy. Used to be you have to pay 9 yuan, to get a divorce in the Civil Affairs Bureau, but now you don't even have to pay. You just, as long as the two parties, both consent to the divorce, there's no argument. You can just go to the Civil Affairs Bureau, get a divorce on the same day, right? So I think that 85% of divorce is kind of lost in the book. Not in this book. I think in all the 3 books, all the trilogy I mentioned on divorce cases, because all of them focus on court, on the judicial procedure to divorce. And then of course you give this very strong impression there are all kinds of these kind of obstacles, problems, for women to get divorced, and all the kind of inequalities, discrimination, physical abuse, domestic violence. All those are true. But at the same time, I think it's also important to keep that in mind. 85% of the cases actually were outside of the court. And what happened to that 85% of cases, I think is also worth studying. And unfortunately, so far, I haven't seen anybody actually analyzing the divorce. We won't call divorce disputes, but the divorce is processed by the Civil Affairs Bureau. I'm pretty sure there are also gender inequalities, there are discrimination, there are all kinds of problems happening in that channel, but that has not been studied so far. So that's one data limitation. But there are other data limitations because all the data focus on judicial decisions. In other words, I mean, Qian mentioned this. This is what judge written in the decision itself. So a lot of other things that happened during the dispute resolution process was, left out of the judicial decision, of course. And what happened during the court hearings, during the judicial mediation process, and how the two parties actually argue, and how the judges actually try to do those things. Of course, Ke Xin's work was quite in earlier. They present some ethnographic details about those things. Kind of shed some light on that, but still, kind of we only have a very limited number of cases, observations about what's actually happening in the court hearing process. And also, Li Ke's book also shows something about what's happening in the law offices of basic legal workers, but still relatively limited amount of data. So I think that's where I think a lot more work can be done. And of course, Ethan did a meticulous work using secondary literature and also media reports, archival data to complement the data studies. I can't imagine anybody could do anything even better than what he has done. But that's still kind of only one aspect of the whole divorce dispute process, right? And so to use the kind of the dispute pyramid or dispute pagoda example, Ethan actually wrote an article on dispute pagoda many years ago. So this is really the tip of the pyramid, or the tip of the pagoda, and what's actually buried, underneath the tip was kind of not really much analyzed. That's another data limitation. And that actually leads to the third limitation. I think it's a more substantive limitation about understanding the legal process of divorce. Because I mean, as Ethan showed very clearly, there are two things are quite important in the divorce disputes. One is the so-called breakdown of mutual affection, right? 夫妻感情破裂 in Chinese. So it's a principle in the Chinese marriage law, but also in the more important in the judicial practice. But how does this principle of breakdown of mutual affection implemented? And more importantly, how did it come about in the first place? Right. So because it arises from decades of judicial practice, across China at the grassroots level. Let me give a very small kind of anecdote from many years ago when I was still an undergrad at Beida Law School. I went to a court in Hebei province to do some empirical research at that time. I chat with a judge in the civil division, and he mentioned that, that was like the early 2000s. And he said, very casually, he said, oh, whenever there is a divorce case, first of all, he said, half of our cases are divorce cases come to it's a rural court in Hebei province. And then he said, all the divorces come to us. When they came, we will kick them back. Because at that time, you were not required to file a case. Case filing requirement was only became a requirement, I think, in the mid 2010s, right? So at that time, judges can just refuse to file the case and basically tell the litigants to go home and then wait for a month and then come back, right? So that kind of practice, what Ethan called the divorce two-first. In other words, you have to file twice to get the judge to hear your case, has always been there. And it has all kinds of grassroots variations across China. It was an informal practice way before it became a formal practice in the law, right? So I think that kind of historical lineage of the kind of that leads to the what Ethan called the divorce two-first, the principle of the breakdown of mutual affections, and also the kind of the physical possession of the child, and how did that principle came into being, right? All those things are kind of cannot really be fully explained by the big data approach. We have to go all the way back, I think, to do historical archival work to figure that out. I think Li's book partially did some of that work, but still, I think there are more important theoretical work to be done. Because, I mean, the more general theoretical point, that's kind of moving to my last comment, which is like a lot of these so-called law in action in the practice of Chinese dispute resolution, we just take them for granted, and then it's really hard to figure out how did they originate in the first place, right? And then how did they evolve over time, right? So I think, the breakdown of mutual affection is just a great example. I'd love to just have an article, just look at the history of the breakdown of mutual affections over time and figure that out, right? And I'm saying I'm going to end with a theoretical comment. So my theoretical comment is really on the kind of the theoretical framework that Ethan used to frame the book. I think Ethan mostly drew on two very famous theories in law and society and also in social sciences more generally. One is the new institutionalism. I mean, that's where the word decoupling came from. Like the one meaning, of course, decoupling is about divorce, but the theoretical meaning is really about the decoupling between formal institutions and the actual judicial practice, right? And that came from the new institutionalism in sociology, right? And I think decoupling is the most appropriate metaphor to analyze this situation, because there are a lot of decoupling, institutional decoupling in Chinese legal practice, not just in divorce, in many other places too. But I think there's another aspect of the new institutionalism, which is about diffusion, institutional diffusion. In other words, the basic assumption is that all the organizations in the same field will gradually become similar, right? And that diffusion part, no matter you talk about global diffusion from outside into China or the diffusion within China, was not in the book. And I'm actually even not convinced that diffusion is part of the story. Because I think a lot of, if you look at the historical evolution of China's marriage law and the divorce practice, I think a lot of them are more bottom-up, grassroots-driven processes than kind of like the institutional diffusion as the new institutionalism would argue. So that's kind of one theoretical question. The other side of the theoretical question is on the street level bureaucracy, which is another very famous theory in law and society and social science that Ethan used to explain the behavior of grassroots judges in these divorce cases. I think it's absolutely true that these judges, because they're street-level bureaucrats, there's no doubt about it, they are street-level bureaucrats. So they have a lot of, I mean, if you look at Lipsky's original theory, he argued that street-level bureaucrats have a lot of power and discretion, right, than the law or the rules that actually grant them, right? That's why they can actually often, police officer can abuse their power much more easily, in the middle of the night on a highway than a police chief, in her office, right? But same thing with judges. But I think there's something different about Chinese judges if we want to apply the street-level bureaucracy theory here, which is, I think Chinese judges, do have a lot of power in a particular case, but that doesn't mean that they have a lot of discretion. I think Chinese judges actually have very little discretion in many of these cases. They're very powerful, of course, vis-a-vis the plaintiff and the defendant. But I think precisely because all these principles and practice has been so institutionalized and entrenched and also embedded in the judicial practice for such a long time, I think, and especially with the rise of the artificial intelligence, all these kind of more modern ways to control the court and the processing of cases, I think Chinese judges actually are the kind of, they're only half the classic street-level bureaucrats that Lipsky was talking about. They're very powerful, but they don't have a lot of discretion in doing what they want in the actual practice. So I will stop here. Thank you very much.
Ethan, do you want to respond quickly to these comments, or do you want to take questions from the audience?
I think I can, in responding to some of the panelists' comments, I think I can also handle some of the questions in the Q&A. But first of all, let me thank Chen and Sida for really great and thought-provoking comments and really gratifying comments. I'm delighted. Clearly, you guys get it. You get what I was trying to do, and it's validating. And I'm glad that that I seem to have achieved at least most of my goals in writing this book, and that for the most part, you're persuaded by my arguments and approaches. I'll start with Chen's questions, and first of all, I'm sorry that you spent your so much of your time in Lisbon reading this book instead of actually enjoying the city and the conference. But I'm a little bit less sanguine, I think, than you are about the promise of really leveraging online judgments kind of as a substitute for field work. I'm not, probably less optimistic than you are about this. I hope I'm wrong. I worry a little bit that that my study is kind of like the most that we can do actually, and one thing that I neglected to mention in my comments, I was talking about the time period that I cover, 2009 to 2016. We can't, and I said, well, we can't, I don't really know if anything improved after 2016. And the sad reality is that nobody can know, because the Supreme People's Court prohibited the online disclosure of divorce decisions beginning in October 2016. Like, that's why my time period ends in 2016. So divorce cases were basically banned, like beginning in 2016. They're not on, like, if you go to China judgments online or some of the other, you search for divorce decisions, you'll see like millions of them still like published after 2016. However, they're designated as basically only the metadata are available. Like the full text of the decisions themselves are not available. You know, the numbers are kind of padded in that way. You know, are there other ways to get access to divorce judgments after October 2016? Maybe. Some scholars are very well connected, but will you know, they might be able to get the collections of decisions from the basic level courts in one municipality. Somehow, you know, Zuo Weimin at Sichuan University, he's always able to get lots and lots of data from you know, city C, I mean, right, Chengdu, I mean, or province S, Sichuan. That's and maybe there are ways people will, but like, you know, from every basic level court in a province or several provinces, I just don't know. And then there are the questions about censorship. Like, you know, Ben Liebman is and his collaborators have been studying this issue of you know, trying to figure out what kinds of cases are getting removed from these online repositories, right? Getting scrubbed. And there seems to be a lot of scrubbing that's going on in lots of places, including these databases. I'm just not sure what we're going to be able to do with these cases. You know, one thing that I think I did though in the book was to demonstrate that, you know, the cases that I was able to collect are very representative. Like, there have been lots of debates among Chinese scholars, actually scholars all over the place, about how representative these online collections of court decisions are. And study after study has shown, well, you know, that the disclosure rate is only about 40%. And so people are like, well, wait a minute, if only 40% of cases are getting posted online, then I mean, that's not super high. And what about the other 60%? Are they systematically different, right? The 40% that are posted, are they systematically different from the 60% that are not posted? And one of the things that I show is that it's like, hold on, it's this 40% disclosure rate is wrong. I mean, that's true if you include all types of decisions. There are many different types of decisions, right? There are trial decisions, right? These are adjudications, the 判决书. There are also, but we know that something like 25 to 30% of all court decisions, civil court decisions, are mediation decisions. They're 调解书, right? Those are generally not published at all. They're not posted. We also know that another 25% of civil court decisions are 裁定书, these sort of like procedural rulings or just basically approvals of requests. They're very kind of pro forma. Those are often not published as well. So if we limit the analysis to what we're really interested in, which is verdicts, right? 判决书, the disclosure rate is actually like quite high, between 60 and 80%. So that really changes things. But what about other kinds of cases? You know, we'll just see. So that, I think, answers some of your questions about, you know, how to use online judgments. The other thing is, like, we benefited just from good timing. The Sida mentioned that at the Supreme People's Court's China judgments online, the 中国裁判文书网 went online in 2013, so almost 10 years ago. Prior to that, individual courts, well, actually provincial high courts had their own websites, and a lot of those stayed online for many years afterwards. Like while they were sending decisions to Beijing, to the SPC, they were continuing to maintain their own kind of local websites. Those were sometimes really easy to scrape because they're very old websites, right? They're pretty primitive websites. And that we just got really lucky, and we were able to scrape from these old primitive websites, and some of them, like Henan, for example, a lot of the earlier decisions, prior to 2014, actually, they never even sent to Beijing. They never ended up on the centralized national website, the China Judgments Online. So the only place to find them was the provincial high court website. Those provincial high court websites are pretty much, they're all offline now. And China Judgments Online is almost impossible to scrape. Like, I don't know anyone who's able to scrape that anymore. And even if you can scrape it, it's unclear what's been removed, right? And so, for all these reasons, I'm just not as optimistic as I used to be. Your question about how to attract a wider audience, like a public audience, it's something I really want to do. I've been wanting to do this from the very beginning. Because it's like, who's going to read a 550-page scholarly monograph, right? I mean, my hope was that by making this public, like open access, freely available online, that somebody would do that for me. Like, someone would, hopefully some people in China would be posting, blogs and getting the word out and spreading the word, or teaching about it, or that even internal, like, white papers or something. I want to do something, kind of write something more public facing. I just need to find time to do it, and I'll do it. So that is a goal of mine. How did I deal with these difficult and troubling cases? I mean, it's really hard. It's really hard to read these cases. They're very, very upsetting. And I'm really glad, Chen, that I was able to help you restore your friendship with your friend from law school who became a judge, because for a long time I too was just like really pissed off at judges, and I thought these are just like horrible people. But actually, over time, I came to understand that like at a personal level, I'm sure that judges are very sympathetic. They're very sympathetic at a personal level. Like they want to help, but they just can't. There are too many constraints. There are these structural constraints on their ability to help women. And I tried to avoid making a cultural argument about judges. I mean, to be sure, culture does matter. I mean, we know that. Patriarchal cultural values. I do spend a lot of time kind of writing about that and about political ideology. I mean, these are cultural influences, to be sure. But the structural constraints on judges, I think ultimately are more important. Their working conditions and their coping strategies that just make it impossible, and the unwritten rules as well that you mentioned, and that you referred to as legal pluralism. And I think you're right. I mean, legal pluralism is one way to characterize it. Absolutely. And Sudha also, really honed in on these sort of, these unwritten rules, and wanting to know more about where these unwritten rules come from. I too was fascinated by this. And you're right. You need a totally different research design to kind of trace the origins of these unwritten rules. It's like, why is it that, across the entire country, 3,000 basic level courts are basically all writing the same kinds of court decisions? Like, how did that happen? These court decisions that are completely, decoupled from the law, from the written law, right? Black letter law, in the marriage law and all the Supreme People's Court, the judicial interpretations that provide guidance to judges, and civil procedure law, and all these things. Like, where did these alternative norms come from that are so uniform, right? Sudha was focusing on kind of grassroots variation, but actually I'm more struck by the consistency across basic level courts, and so. There's got to be other forms of guidance that are not kind of codified or written as Supreme People's Court judicial interpretations, and like how this happens. Like, what are the processes? What are the mechanisms? And that is, and it's not just limited to this. I mean, Sudha, you're 100% right. I mean, there are so many examples of decoupling across all kinds of cases, and so where the actual judicial practices deviate so much from what the law kind of tells judges that how they should be deciding cases. So where did these other where did the actual practices come from that are so consistent across basic level courts? I also agree with Sudha 100% that somebody needs to study what's going on in the civil affairs bureaus, the civil affairs system. I haven't seen any. I mean, that would be like a great dissertation, right? To study civil affairs divorces and figure out like how people get there. And this is one way that I can address one of the questions in the Q&A box, which is, so this is I'll just read it. That I argue in the book that judges are acting in part to manage their workloads. I realize judges can save themselves time by rejecting a petition, but since many of the cases come back again and again, aren't they just adding to their workload in the long run? And so that is, you'd think intuitively, right, that's what would happen. It's like, wait a minute, why would they, by trying the same case 2 times, 3 times, 4 times, aren't they multiplying their workload? Aren't they adding to their workload? And they're actually not. It actually saves them time because, I mean, most of these cases, some of the cases do boomerang back, right? They come, but actually most of what I show is that most of the cases don't come back. And in that way, that their routine practice of denying divorce petitions on the first try, they're actually shrinking their dockets. I call this practice a docket shrinking machine. I say courts are leaky. They leak divorce cases because once they deny a divorce petition, most of them don't come back actually. And I strongly suspect, I mean, they must, most of them must end up in the civil affairs system. And men, the abusive husbands, they know this. They do this very strategically. I mean, they want the property, right? They want the house. They want the children, and so they say when their wives, so they withhold consent to divorce, and if they withhold consent to divorce, they can't go to the Civil Affairs Bureau, right? Because the condition of going to the Civil Affairs Bureau is that both sides agree that there's mutual consent, it's uncontested, they agree on all the terms, and so the husbands will say no, I don't agree, or I don't agree on the terms, and so the wife is forced to go to court. And the husbands know that the courts are going to deny the petition, and that the wife in desperation is going to say, okay, well, it looks like the only way I'm going to get divorced is by giving everything up. If I give up all my rights to property, give up all my rights to child custody, only then will my husband consent, and then we can get the so-called the xie yi li hun at the Civil Affairs Bureau. I suspect that that's probably what's going on, but we got to study this. I mean, that's sort of a blind spot. There's definitely movement between the two places. Some cases that start in the Civil Affairs Bureau bounce into court. Some cases that start in court, they bounce into the Civil Affairs Bureau. There's definitely an interaction between the two. There's a question about the gender of the judges. Did that make any difference in the decisions? And I found no difference. I found no difference between, and I did actually look at that. I looked carefully at that. Although the genders of judges are not disclosed in the court decisions, only the names of the judges are disclosed. But there's some open source code, that they're gender guessers, right? They're not 100% accurate, but they're pretty accurate. You with a high degree of confidence, you can guess the genders according to the names, the Chinese characters in the names, and it really, female judges, they judge no differently from male judges, and there are other studies that have shown the same thing. And again, I suspect that the judges themselves, they would at a personal level, right? They would like to help. They're more sympathetic. I suspect that women judges are more sympathetic than men are, but But women judges also, I suspect, feel particularly vulnerable, particularly at risk. These, particularly in domestic violence cases, these abusive men with documented histories of violence, and they're in court threatening to carry out more violence. I mean, He Xin has written about this as well. Like, they're in the courtroom, and I have a number of cases in the book where they're in the courtroom. They're telling the judge, like, if you grant this divorce, I'm going to kill my wife, and I'll kill you too. They say this directly to the judges, and there are a number of pretty high-profile murders of judges. Judges have been particularly in family court judges have been killed in divorce cases, and I think women feel probably more concerned about this, rightfully so, than men do. They've been attacked in court, the easiest thing to do is just to deny the divorce petition. Another way that this helps reduce judges' workload is that they'll tell the litigants very directly. They'll say, look, you're not getting divorced today. I'm not going to grant your divorce today. But if you guys work it out amongst yourselves, right? Come to an agreement yourself. Work out all the terms of the divorce. If you come back after 6 months, I'll grant the divorce, and that way they sort of I guess mollified men. They sort of appease. They kind of cool off these angry men who don't want to get divorced, or they want all the property in the divorce. So men definitely, like, they win. They come out ahead in this process, regardless of whether the cases come back to court or whether the cases bounce into the civil affairs bureau. There's also finally a question about, do judges receive training on how to decide these cases? Are written decisions describing the facts required? Oh yeah, I mean, they are required to. The plaintiff's petition is generally reproduced in the court decision, and the defendant's defense statement is also appears, and so and then the evidence that's submitted by the litigants to support their claims. All of that is described in these court decisions. These are rules, right? The rules of the court require judges to describe all of the evidence, as well as their assessment of the kind of the authenticity of the evidence, whether they rule to admit the evidence or not. If they don't admit the evidence, they have to explain why they don't admit the evidence. So there's lots and lots of detail in these cases. That said, they're not super long. As Chen pointed out, they're pretty easy to read. What are we going to do with our 1 minute left?
I guess we can go slightly over the time limit that's scheduled, so there's no technical challenge to that. As I understand, one of our colleagues, Jet, has some questions for you as well. But before I invite Jet to share his comments, I want to follow up on some comments made by Sida and also some of the participants in the chat box. And since the pressure of workload is one of the major drivers you mentioned that have resulted in the decoupling practice in divorce cases, and you have 2 chapters devoted to discussing the issues, chapters 4 and 5. In chapter 5, you've mainly discussed the issue of sort of the implicit two-trial norm as a result of the compromise the judge has adopted to cope with the increasing workload. And in chapter 4, you're focused on the more sort of general trend and the coping strategies for judges in Chinese courts. And I've been trying to sort of make connections between the different moving pieces of the coping strategies you described, especially in divorce cases. How do the other 2 coping strategies that you mentioned, meaning the inclusion of layman assessors and also the introduction of the simplified procedures, how do these coping strategies affect adjudication in divorce cases? For instance, to what extent have you noticed the influence of simplified procedure on the procedural rights of the plaintiffs and defendants in those cases? and also for the inclusion of layman assessors, since they are not bound by the institutional logic of preserving social stability, are they more free in sort of expressing their own opinions in divorce cases, or are they similarly threatened by the fear of their life or other danger from the angry husbands?
Do you want me to answer that first, or do you want Jed to go? I can answer that if you want right now.
Sure. Let's see. Jed, can you unmute yourself and speak up? Or
okay, if we have time, sorry to. Okay, I guess real quick. I had some sort of like since there has been a lot written in this area, I did when I was reading through the book today. A lot of sort of theoretical implications came to mind. One is, from a traditional law and society view, right? We have this frame which you mentioned of like bargaining in the shadow of X law, right? And divorce law is one of them earlier. Given that you feel that you use this method to divine a type of information that isn't otherwise accessible or recognized by other people, what does this say about the ability of individuals to even know what they're bargaining necessarily in the shadow of, right? Even if we put aside the fact that 85% of the cases are happening in another arena, right? How can we think about how people would be influenced by their understanding of what's going on in the courts if these things aren't perceptible? And the flip side of that is then the institutional aspect, right? What do institutional actors know about these phenomena, right? That you sort of tell a story, well, there's sort of been neglect, there's all these institutional drivers with the roles of judges, but you add that in with patriarchy and you naturally get some adverse consequences, right? But is there any sense that actors within the system could even possibly understand this in a clear way, given that they don't have these types of tools, even if they necessarily wanted to intervene, even positively or negatively, right? We have a lot of signs now that there's lots of regressive gender norms, right? Coming into these fertility types of debates where they'd be like, oh, this is something that we should encourage. And then the second part, I guess, sort of methodological counterfactuals. I really like that you sort of take a lot of swipes at these sort of large and quantitative studies that sort of go over all these endogenous issues. And you look at the limitations of the method. But if you could go back again, and there was some piece of data, right, that's currently absent, right, whether it's like ethnicity or income level or something that you could get, what is it that you sort of most wanted to see? And given now that we've had 3 books with quite different methodological and theoretical positions, if you could do field work, or if you could do anything more in this area for like data collection, what do you think is left to be sort of most complementary?
Great questions. I think I'll start with Jed and then move back to Ying's also really terrific question. I mean, the bargaining in the shadow of the law. I mean, I think that the simple answer there is that it would be more bargaining in the shadow of the 2-trial norm, right? That's emerged, the divorce THUR. I think this is well known, and I think people who are trying to get divorced in China, they kind of know what's in store for them. And so, you know, it's the I mean, what are they bargaining in the shadow of knowledge that without the defendant's consent, so in most cases the husband, right, consent to divorce, the petition will simply not be granted, right? So that's what, you know, the knowledge of almost certain failure to get to succeed in an effort to get divorced. That's the context in which bargaining occurs. And if people go to court kind of unaware of this, they don't know about the 2-trial, they're going to learn about it very quickly. And so the bargaining could I mean, even if they don't know about it, right, they're going to be bargaining pretty quickly. They're going to go into court, and then 5 minutes later, they're going to be walking out of court, rejected, and that could be when the bargaining really begins, and they have to make a choice. So I think that's what's going on. I don't have a good answer to your second question. I mean, I mean, obviously, I would have loved to talk to judges. And just ask them, like, you know, ask them Suda's questions, like, where did this come from? would I be able to? I mean, even if I could, sort of forgetting about the pandemic and all of that, closed borders and stuff. Actually, a lot of these challenges, the fieldwork challenges that Chen was talking about, I mean, they've long preceded the pandemic. It's just become increasingly difficult to do fieldwork, and particularly, I mean, in the court system. I mean, He Xin's ability to, his network is amazing, and his ability to get judges to talk, and his ability to get into courts and see what's going on. Li Ke as well. I don't think I'd ever be able to do that. So I don't know. I don't have a good answer to your question, but obviously, I guess we just kind of have to, maybe we have to read all three books. And take away different things from the different methodological approaches. I mean, they all kind of complement each other, and they sort of triangulate, and they're like the different parts of the elephant. The proverb with the blind men and all of that. Going back to Ying's question about the coping strategies, the increasing use of the simplified procedure and these other, like that in particular. The use and abuse, I would say, the abuse of the simplified procedure. I mean, divorce cases show this, that just how truly perverse the use of the simplified procedure has been in divorce cases. I mean, judges, they don't want to deal with complicated cases because, they're difficult, right? They're time consuming, they're fraught. I mean, people are emotional, they're angry. Litigants get really worked up and they threaten each other. And like I said, they threaten judges, they threaten social stability and judges. I mean, that is like the biggest concern. So when judges see that a case involves housing, debt, or like a business, children, I mean, they know immediately. It's like, well, I'm not going to grant that divorce. I mean, that there's no way I'm going to grant that divorce. So they've already decided that they're going to deny that divorce petition. So how do you deny that divorce petition quickly in a way that consumes minimal judicial resources? They apply the simplified procedure. So the more complex the cases, the more likely the judge is to apply the simplified civil procedure. And conversely, the cases that are actually relatively simple, so these are the cases where there's no marital property or no claims for marital property, no children, so no child custody. These are the cases that judges are like, maybe I'll grant that divorce, especially if the defendant consents to divorce. And so if they decide beforehand, it's like, okay, this is a straightforward case, both sides agree, nothing is contested, I'm going to grant that divorce. They're actually more likely to apply the ordinary civil procedure to cases that are simpler. So it's like completely upside down, totally perverse. And a lot's been written about this. Actually, a lot of legal scholars have complained about, just the sort of like arbitrary application of the simplified civil procedure, which is also, and with the full support of courts and the full support of the court system, actually, as a way to kind of maximize judicial efficiency, particularly in light of a national shortage of judges. I mean, that to me is like the biggest issue. I mean, in terms of policy recommendations, China's court system just needs more judges, way more judges. And how we ended up with this the judge quota reform, like reducing judges. I can sort of see the logic. Okay, if we put we create more clerks who can do a lot of the kind of the clerical work and prepare the cases and organize the files and then write the decisions and all that stuff. That'll like allow judges to be more specialized and efficient and all of that. But the court system just needs way more judges. That's it.
Okay, this is amazing. I really enjoyed the conversation. We can keep this going all night long. Since we already exceeded the time limit for the talk, I think we have to keep on with our conversation in offline later on. So closing note for tonight, I'd like to invite all our participants to thank our three wonderful speakers and all the participants that have stayed up so late for this talk, and the CCPL team, especially Phoenix, for putting this event together. A recording of this video will be uploaded to CCPL's YouTube channel shortly after. So feel free to review the video or share the link with others if you like. We also have other events scheduled in the coming semester on China's gender issues and judicial studies. So if you're interested in those issues, please check the updates of the CCPL website and the HKU Law Faculty's WeChat account. Thank you again and have a good rest of your day.
Thank you, Ying, and thanks, Chen and Sada. Thanks so much. And the audience. Good night, everyone. Have a good day.
Good night.